procedure law and the legal clinics. So we have the students here and also the advocate, the public defender, so that they can hear a new perspective in another word which came from Spain. I'm almost believe that the word Spain that they knew is about football club.
Oh yeah, for sure.
They have Barcelona, Real Madrid, of course Seville, Sevilla. So mahasiswa sekalian dan Bapak Ibu sekalian, beliau, his name is Professor Raul Gabriel Sanchez Gomez. Is it correct?
It's perfectly fine.
I'm the articulation. He's from Universidad Pablo de Olavide.
You
Like that.
Speak Spanish.
Okay. Today beliau akan membahas tentang hukum acara, ya, hukum acara di Spain dan juga tentang legal clinics. Legal clinics itu seperti kalau di tempat kita adalah lembaga konsultasi dan bantuan hukum. But I would like to introduce to my student that Mr. Raul Gabriel Sanchez Gomez is one of the lecturer as a professor since 2012 in Universitas Pablo de Olavide. And then beliau menyelesaikan studi di Sevilla, di universitas yang sama, kemudian gelar master ada di Universidad Carlos III de Madrid. Yes, I found this at your ORCID, and also his doctor at 2014. Okay, I think it is a good time, yeah, to hear anything about the procedural law and legal clinics that happening in Spain, but also you can spread it out when you have any experiences all over the world about the procedural law and legal clinics. You can tell us, yeah. Okay, time is yours. Define it.
Thank you very much, Professor. Should I take here?
You can sit, you can walk, or yeah, it's fine.
Thank you.
This one. I mean, I'm sorry.
Thank you.
We use the.
As you wish. I'm okay. I stay here. Thank you. Thank you very much. Salam alaikum. For me, it's a pleasure to be here. God thanks to all my colleagues for the kind invitation to participate in this event, and the extremely warm way they treat me the week I've been in Yogyakarta. So I will start my intervention with a threat, like Terminator, I will come back. I promise. Okay, first of all, I need to apologize to all of you because I think the hot weather here mixed with the AC make me a little bit cold, and I spent a really bad night of coughing and those kind of things. So my head is not that good. It's not that good, but I'll do my best. On the other hand, I'm sorry too, because in Spanish traditional law we don't use PowerPoint, or we don't use documents to support our speech. Under the maximum that you cannot teach what you don't know, so we don't use PowerPoint. You just teach, you just offer what is in your mind. For me, it would be easy to have a PowerPoint with all the details, and you would say, oh, this guy knows a lot about law. But who knows? Maybe not. Maybe I'm just reading. Okay. First of all, if you wouldn't mind, I thought about how to prepare this intervention, the speech, and I said, okay, talking to the students about boring general theory of law, of even procedural law, they will hate me, probably after 2-hour speech. So I decided to bring a little bit knowledge about how procedural law, both in civil and criminal, operate under the Spanish and the European Union law, because it's attached to each other, you know, that we are part of a big union called European Union, and our law is linked to what previously is agreed at the European Union. We will see that in a very clear way regarding criminal procedure law, or even criminal law. On the other hand, we have the civil law, and I would love to show you how the judicial organization and the different procedures works in Spain and probably all around Europe, because we have the same legal tradition. After that, at the end of the speech, probably link that to what we are doing in the legal clinics, legal aids units in Europe, because it's a model that is completely different to the work you guys are developing here. I had the chance to go to yesterday night to the legal aids unit, and come on, the structure is unbelievable. We don't even can dream to have that in Europe. You know, it's unbelievable. We have a different perspective of what legal clinics should represent at the European stage. Our legal clinics are more related to teaching, to the learning-teaching process of students, and to approach our students to a broad concept of social justice. I'll explain that later.
Can I translate it?
Yes.
Okay. Beliau semalam itu kan main ke klinik kita di LKBH. Saya bawa setelah beliau selesai urusan di Fakultas Ekonomi, saya ajak ke lembaga konsultasi dan bantuan hukum Fakultas Hukum UI, di tempat kita punya laboratorium itu. Beliau melihat begitu banyak personel di sana, ada advokat, ada mahasiswa, melihat strukturnya, wow, ini luar biasa. Sebab apa yang dilakukan di Spain itu sebatas mahasiswanya itu melakukan kajian-kajian dan do the recommendation for the state or the government, right? Nah, kemudian melakukan kajian by research itu disampaikan kepada para pemegang kekuasaan untuk kemudian melakukan perubahan-perubahan. Di tempat kita itu sampai dengan giving such legal assistance gitu, atau memberikan pendampingan hukum. Nah, maka ada beberapa mahasiswa di sini yang itu juga merupakan bagian dari LKBH UI. Nah, yang saya pernah juga ceritakan di kelas. Okay, you can continue.
I'm sorry. I thought you could understand English. For that reason, I was talking too fast. You know, it's okay. I think you can understand a little bit, but probably I'm really sorry. I'm really sorry. I thought I was in Germany. You know that. I'm really sorry. I'll go a little bit slower and pointing the main points of the intervention. Okay. Let's start with the big difference, or how we manage, how we structure the civil and the criminal procedure under two main principles. The two main principles that I think is one of the main difference that you can find with procedure, civil and criminal procedure structure here in Indonesia. For us, regarding civil procedure, we have two different procedures, two different kind of procedure, all related to what we call principio dispositivo, which means dispositive principles about, how can I say this in English, which means that the legal parties, brings the facts and brings the evidence to the judge table, which means that the judge is tied of what the parties would present in their allegations. That's type 1 of civil procedure. Type B are the most interesting civil procedures, what we call imperative procedures, because you have some public interest related, linked to those kind of procedures. For example, child protection. For example, matrimony issues. For example, people with disabilities rights. For example, inheritance law. There's a public interest linked to those kind of civil conflicts, and for that reason we have a sort kind of an hybrid procedure where the judges has the faculty to bring facts and evidence to the table, no matter what, if the parties brought them or not. So we have two different kinds of procedures in the civil procedure. The ones that are the general ones, where the parties bring the facts and the evidence. For example, small claims regarding money debts. That's a matter between parties. Business dissolution. That's a matter between parties. But in the second hand, for example, when we need to appoint a judicial guardian ad litem, and to protect the rights of a child or of a person with disabilities, the judges has 100% freedom to put in the table whatever is needed to achieve that protection. Okay? So we have two different options. It is true that the Spanish civil procedure let the judges bring evidence to the table in any procedure, the general type, the type 1 and the type 2, but in type 1 is kind of restricted. Should be a special and exceptional decision that should be specially justified and is unusual. But the Spanish law and the European law let the judges do so. That's what we call principio dispositivo, dispositive principle. Prior to go with the criminal procedure, if you want to translate.
Okay, that's fine. Ya, beberapa hal mirip dengan kita. Jadi di dalam civil procedure law atau hukum acara perdata itu beliau menyampaikan parties to parties, pihak dengan pihak. Kalau di tempat kita ya artinya masyarakat dengan masyarakat, orang perorangan. Tadi beliau menyebutkan ada inheritance case kayak kewarisan, guardian law atau tadi berkaitan dengan pengampuan di dalam pengampuan maupun perwalian, dan semuanya haruslah berbasis pada bukti dengan disampaikan kepada hakim. Jadi kita ada sesuatu yang sama. But we are talking about this civil procedure. Is there any pre-examination? This is suitable for judge to examine or not? Something like that, or how is in Spain?
Exactly. In Spain we have a legal profession that we call judicial secretary is sort kind of a clerk of the office, one per judge. That is the one that preliminary will analyze the contents of the claims and check that the claim follows the rule of law. If the claim does not follow the rule of law, the secretary will request to the parties to solve that issues within 5 days, and if not, the claim will be diminished. You know? So we have the clerk of the court
check,
will analyze the preliminary, but we have also with the at the imperative type number 2 of civil procedure, normally we have a jurisdiction that is called voluntary jurisdiction, which is a place with the same judge that we decide later in a controversial jurisdiction, in the normal jurisdiction, regarding the type 2 of civil procedures. For example, if we need to protect the rights of a person with disability, we go to the judge first and try to have a friendly solution proposed by the parties.
Wow.
You know?
Yeah.
But if the parties present contradiction, that would go to the general procedure. It's what we call a voluntary jurisdiction. Wow. For imperative procedure. Same thing in child protection, same thing, for example, when you need to divide a property, same thing when you decide to an international adoption of a child. Yeah. You first go without a conflict of interest to the judge and say, okay, me and my wife want to adopt this kid that comes from whatever country. There's no conflict on that. There's a public interest that should be stamped by a judge. Same thing with a person with disability. There's no conflict if the person with disability and the guardian ad litem appointed by the family has no controversy, they all agree. You just stamp it so the guardian ad litem could operate in the legal traffic under the name of the person with disability. But in the case, one member of the family or the person with disability would say, no, I disagree that Raul is the guardian ad litem of his brother. We would go to the normal jurisdiction, to the general jurisdiction in order to argue. Which means this previous step of jurisdiction is not controversial. Also, we have something new under Law 1/2015 of the 2nd of January, which introduced as a matter, as a requirement to proceed prior to take legal action, what we call, I'm positive you also have it here, the alternative dispute resolution methods. Yeah. Mediation, conciliation, and other stuff. We have that as a requirement. I mean, it is mandatory to take legal action against the defendant, that prior of that, you make proof that you try to solve the conflict in a friendly way. Otherwise, the secretary of the trial, of the court, will dismiss the claim that the plaintiff previously proposed. So you need to go to a mediation process or to an ADR process before claiming at the civil jurisdiction. Also, you have other possibilities, what we call preliminary hearings. Not preliminary hearings, we would say preliminary measures. That's kind of a really neat from the Spanish system, which means, and it's a funny instrument, prior to take legal action, you can ask the potential defendant that is not already sued about documents or situations related with the claim. For example, I want to sue a hospital because of bad practice, okay? I will demand that prior to take legal action, I want all the records. I want to sue a company for not using the funds of the company for the proper use they were agreed. I will ask for all the documents, economical documents of the company and how the decisions were made prior to take legal action.
That can't happen. That can be happen in here.
Can happen?
Yeah, they will face the hospital or hospital lawyers, and then they will give you nothing because in Indonesia, based on what you ask, so you have to prove it. No, and you have obliged to find the evidence by you, not from your defendant. But if defendant did not submit something or any evidence, so the case will not accepted by judges. I mean, at the end, the decision will call as in need on conflict verklaard, or the lawsuit will assess this is not accepted because formally of lawsuit is not required by the plaintiff. There is no proof, there is no evidence, so you cannot prove anything. That is one of the obstacles here. Yeah.
So can you say that again, because I don't know if I understood well.
Okay. If I'm not mistaken, in Spain we can ask our opposite evidence
to
bring to the judge.
Yes.
But here is not.
Oh.
Because by the legal principle, it said if you make a lawsuit, you have to prove it by your own. How can be? It's your business.
Oh.
Such like that.
Oh.
So before they go to court, they go to hospital or company that make a damage, they will see the lawyer first. Yes, and they said, this is confidential for us, and you are not have rights here. If you want to go court, so we'll see you in court.
I see what you mean.
That's why.
Is that we have a principle in civil law, also in European law, for example, when you go to the European Court of Human Rights, that is called principle, I'm going to translate that, principle or for who is easier to bring evidence to the table. It's called facility evidence rule, which means that if it's easy to bring an evidence for the defendant than for the plaintiff, the defendant has the obligation to give evidence, to the judges.
Yeah.
It's sort kind of constitutional human rights point of view that was brought from the constitutional courts to the civil courtroom. If any of you wanna check it, it's under Article 217 of civil law, civil procedure rules.
Okay, before you continue, jadi ada perbedaan yang sangat, apa saya katakan ya, jurangnya itu jauh sekali. Bagaimana sebenarnya hukum acara di Spain itu betul-betul mengcover both side gitu, mengcover baik penggugat maupun tergugat. Dan sebelum case itu masuk ke pengadilan, ada tadi disebut dengan preliminary examination. Apakah kasus itu layak diperiksa, bahkan di dalam proses perdata. We have a preliminary examination like that, but only just in administrative court.
Wow.
Not in district court, both the criminal, the civil and criminal court.
Wow.
That's the difference.
That's a big difference.
So, like you said, in administrative court atau di peradilan tata usaha negara, we have also clerk that will take first action. Is there any requirement fulfilled by the lawsuit yet or not? And then if it's okay, then it will submit to the panel that has been elected by the chief of the court. Jadi kalau di pengadilan tata usaha negara, teman-teman, bedanya dengan peradilan peradilan perdata di pengadilan negeri, khusus di pengadilan tata usaha negara itu ada yang namanya pemeriksaan persiapan. Apakah gugatan tata usaha negara ini layak diperiksa oleh pengadilan? Nah, seperti yang tadi saya bahas di kelas, ini dipengaruhi oleh Perancis dan Belanda. Yeah, it's causing from French and the Netherlands, right? Ya. Yeah. Tapi tidak di dalam perdata, padahal sama-sama datang dari Belanda. Ini yang kemudian agak aneh. Dan cilakanya kan kalau beracara perdata itu kita nunggu sampai terakhir diputus NO atau tidak dapat diterima, itu artinya case-nya ya nggak bisa lagi diperiksa. Nah, yang menarik di Spain itu tadi ada pemeriksaan pendahuluan sehingga kasus ini layak atau tidak untuk diperiksa oleh pengadilan. There is the interesting things that I just told to them is about the preliminary, not only at administrative but also the civil. By the principle was the civil case is about horizontal relation. So I think we do not have any necessary, or judge do not have necessary to seek it first before they will examine it. So how do you think about that?
I mean, for us it's not it's, horizontal only. Okay. You know, our system is based on the Kelsen pyramid. You know, it's like, so for us how parties and judges operate in courtroom, it's a triangle. Yeah. It's a triangle where the judge is here and the parties are here, and they both operate in every single way. For example, when you consider the right of defense, no, the contradiction, the knowing how to defend your position, we always picture that principle with that triangle. So for us, the relation is not only horizontal, you know, it's triangular, because we have some sort of public interest in every single I would say in every single procedure, even if it's civil, even if it's business, even if it's, you know, we have a decent intervention, decent amount of state intervention in the resolution of the conflicts, even if they are private, you know. That's a cultural point of view. I mean, when you consider, for example, the right of defense, how to become a lawyer in Europe, for example, we're moving into classes.
because this is like another classes. He's coming, and the others were out moving as the schedule.
It's normal. It's normal. So when you consider the right of defense in the European system, for us it's a matter of, it's a state matter to guarantee that every single party is represented by an attorney. And if it's not, the government will appoint one for you immediately. For example, for us, that is established in Article number 6 of Law 1, 1996, which says that if you make less than 2 times minimum wage, I mean, the majority of the country makes less than 2 times minimum wage, that means that almost every single person in the country is entitled of free legal advice and representation. Almost. For us, the right of defense at the civil and at any procedure is a structural matter.
Okay, take a seat and kneel, and we can continue after you.
I gotta say that for us it's really nice. It's really nice to have the class full of people, you know.
Yeah.
In Europe, we don't have that anymore.
Huh?
No, we don't have that anymore. As a consequence of the technology applied to the process of learning, the classrooms are empty.
The classroom is empty.
Yes, are empty. For that reason, for me, this is like going to the past, you know, to a decade ago, where the classes were packed, were empty. Okay. Okay.
Yeah. I think this is suitable for you to continue and then until the end of your speech, because all of them are international students.
International students, okay. But from Indonesia, no?
Well, Indonesia.
From Indonesian,
yeah.
but interested on international law.
No, but using the international language.
Oh, I see.
But we have international student.
Okay.
In the first row. Your name, son, and where you come? Egypt?
Yeah.
Kenya.
From Kenya.
Nigeria.
From Nigeria. That's nice.
Nice.
Okay.
You are from Botswana? Oh, no. Okay.
Does anyone from Spain apart from me? Okay, let's go, if you wouldn't mind, to the criminal procedure. In Spain, we have the professors of procedure law must be specialized in both branch. That I know that's crazy, you know. It's kind of crazy, but that is how things are, you know. Also, before criminal procedure, I told you that I will talk about how to become an European lawyer, you know, because I think that's a good thing to know, how to become an European lawyer. I mean, for us, the system it's really easy. It's really easy. You just need to be 4 years at law school. It's not hard to get to law school in Europe. I mean, it's not hard to get to a normal law school. Probably the top ones are difficult all over the world, you know. So after 4 years of law school, you need to go 2 years through a master's degree. That is called Master en Abogacía y Procura, Master in Lawyering representation, some kind of, sort of, which takes 18 months. After that, you go through a test that is common for the whole country. It's not a difficult test, I can tell you. It is not difficult. The percentage of people passing the test is huge, not big, huge. And after that, you just go to the bar association, pay the money at the bar association to be a member, and you are ready to make a lot of money as an attorney. Or at least try, you know, or at least try. So the system is not that bad. The good point is that no matter where you go, at the European Union, for example, you can study law in Portugal, become a lawyer in Portugal, but you are a lawyer all over Europe. You know, all over Europe, and you can work as a lawyer all over Europe. That means that we have students from different European countries studying in other countries because it's easier or whatever. Nah, not anymore, not anymore. At the very end of the day, if you're going to be tested under your law, you'd rather stay in your country. If you study in Italy, you'd rather be tested about Italian law than Romanian one, which is kind of different. So we don't have a difficult system. The tuitions in Spain for law and the master's degree are low. And when I mean low, extremely low, because we have public interest on this, and the government support students if students study. If a student decide not to study, there's no more support. You know, so it's kinda normal that the tuition is reduced by 99%, which is a lot. And also a student would have things like, for example, accommodation, tickets to eat at the cafeteria, or transportation tickets. The majority of them are giving some money every single year in order to be able to study outside of their hometown. You know, if you come from a small town without university and you go to a big city that has a university, I mean, the government helps you with that. If you study, if 1 year or 1 semester you decide not to study, there's no more support. Okay? So it's not an easy, it's not a difficult, task to become a lawyer at the European system through the Spanish model. It's not that difficult. For us, the classes are divided into 2 different types. Every subject is divided within 14 classes of 2 hours. You know, for example, civil procedure law, 14 classes of 2 hours. Then, if you take those 14 hours, classes, once a week, during seven you will have 1.5 hours of practical classes. So 2 hours of theory for 14 weeks, 1.5 hours for 7 weeks of practice. You know, for example, I do mock trial with my students. We prepare legal documents like suits, like claims, like appellations. We go through a whole process, through a whole procedure from civil to criminal without a problem, which is good because when they start university and when they finish the master, if I'm the professor that teaches them procedural law, they will use, you know that lawyers wear a funny suit over there, no? A funny suit, black suit. We don't use the wings yet, no? That's more British, but we wear a funny suit that we call toga. Toga, okay? They will wear the toga for more than 20 times, which means for the 21st, maybe you can charge your client, you know? Okay, criminal procedure. There's anyone here that want to be specialized in criminal procedure, on criminal matters? There's one? Well, that's, and civil? No one? Or the rest doesn't know yet?
I hope they are not to be a defendant, right?
They don't want to be?
Defendant.
Oh, they want to be defendant?
Oh, no. I just hope they are not to be defendant at the future.
They don't want to be lawyers?
Or, I hope. Because they are still confusing how, which future, my future, I think. Criminal, okay, just one in... How about you, son? Humanitarian, he said.
I'm specialized in that.
Yeah. How about you?
We still got introduced by the legal science, the basic legal science. So I personally don't know what the specialist on, but I personally interested in humanitarian law also. I think it's quite a lot of fun to learn about human rights. And
That's my main topic of research. The master's degree I study and the PhD I study after the master's degree was called Advanced Study on Human Rights, you know. So I spent a lot of years of my life studying the thing, so I understand your point of view. Okay, let's go to criminal if you want. We are what in Latin is called rara avis, which means we are bird. You know, we have a model in the Spanish system that does not follow any system that you have heard before. The European Union has said, come on, Spaniards, it's time to change the system you guys have over there. And we try for 3 times, 3 different governments, try with 3 different draft of criminal procedure code, but no one could implement the code because, particularly, of the huge amount of money that is needed to change the system. However, the European Union will not wait too much longer to us, or for us, because the system we have is based on sort kind of cultural tradition that was brought, is this recording? No? No? Oh yeah, videotape. Okay, in that case. Okay. We have a tradition, you know that part of my country was ruled by Arab people for 7 centuries. You know that. You might, for example, have heard about Al-Andalus. I come from Al-Andalus, from the capital of Al-Andalus, Seville. In Arab, Ishbilia. After that, we have some kind of influence coming from the north of Europe. What we call the Goths, no? The Goths, not the Goths, the Goths. No? The Goths, the Germanic population that, well, established some kind of traditions called, regarding criminal evidence law, what they would call ordalías, that was always related to physical punishment to prove that the gods will support you on your claiming. For example, if the defendant is right and he can survive to put his hand in boiling oil and be alive after 3 years, the defendant is not guilty. You know? So that was called ordalías. We don't have ordalías anymore, for sure. For centuries we don't have ordalías anymore. But we had a little bit of the secrecy that was related to that medieval system. For that reason, the criminal procedure is based on two different stages. Which is different from the rest of the system is the first one. The second one, you already know it perfectly, because it's the accusatory system. You know it perfectly. You go to the trial, defendant, plaintiffs, prosecutor, witnesses, and whatever. You know, it's the same. The reason why we are special is because at the investigation stage we have a different system. For example, who is the one that directs the investigation in Indonesia, the criminal investigation? Probably the prosecutor. First. Yeah, but who is the one in charge of the police officer? I would say, no. The prosecutor will direct, exactly. And when the investigation is over, they will go to the courthouse. Yes. In Spain, we don't have that. Unfortunately, as I said, we try to have that 3 times, but it's kind of difficult. That we achieve that in the next year. What we have is what we call is a pre-trial investigation, managed the same system in Indonesia, managed by the general prosecutor and the police officers. But as soon as special measurements, normally that affects fundamental rights, are needed in investigation, they have to judicialize, the case. And the ones directing the investigation at the procedural stage for us is a judge. And that is kind of funny because the same guy, the same person, I'm very informal, the same person that is directing the investigation against your client, the same person that is deciding the measures that affect your client's fundamental rights, such as phone devices intervention, home dwelling intervention, laptop intervention, whatever, DNA intervention, the same one that is deciding all of that, it's supposed to be the same one that have to look after for your client's guarantees and rights, which is kind of difficult task to achieve. I assume that here the general prosecutor directs the investigation, but If a phone device needs to be searched, you would go to a judge in order to have a judicial authorization to search and secure the device. I would say so, isn't it? Yes. It's what we call a judge of guarantees. A judge that look after the defendant's guarantees and rights. We do have that, but also the judge deciding and directing the investigation is the same one protecting the defendant's rights. For that reason, the European Union said, come on guys, come on Spaniards, it is time to make this happen. Just change the law. Yeah, we're trying, yeah, we try hard for 3 times. We have 3 drafts of criminal procedure code, 3. Come on, and the European Union decide, okay, no more. So, in the criminal procedure, we have different procedures regarding, well, misdemeanors, I think, like here, first-degree felonies, second-degree felonies procedure. No, we have the rule of the 5 years. More than 5 years, go to a procedure. Sorry, 9 years. More than 9 years, go to a procedure. Less than 9 years, we go to another procedure. For us, the jury trial is kinda exceptional. We have a jury trial, but only for a few criminal offenses. If you want to check it, it's in Article 1.2 of jury trial Spanish law. So the European Union said, okay guys, this is enough, and they established a new procedure, which is called Procedure to Protect the Rights and Interests of the European Union against fraud that are up to 2 million euros. In those procedures, we have the same system you guys have. A general prosecutor directing the investigation, a judge of guarantees deciding about the measures that they are asked, and the direction of the investigation by the general prosecutor goes until the very closed door of the trial. For us, nowadays, it's not that way. Probably you would be under investigation directed by a judge if we're talking about first degree felonies. Probably, if we're talking about this, 3-4 years, it's easy. It's easy that you are there. When we consider the second-degree felonies, I mean the things, the criminal offenses that are under 5 years, they normally end by plea bargain. Do you know what is plea bargain? Plea bargain? No? The plea bargain means kind of a deal, of an agreement between the prosecutor and the defendant that will reflect that the defendant assumes guilty and the punishment that is proposed. That is the point of the plea bargain. You assume the punishment that is proposed, so there is the point where you can bargain in the punishment, in the amount of punishment you assume. It's pretty normal at the Anglo-Saxon systems, the plea bargain. Under the European systems, we do have that, but it's not that as usual as in the Anglo-Saxon. For example, let me put these numbers on the table. Under USA federal law, only 3% of criminal procedure regarding federal law goes to trial. 3% in the whole country. That reflects something. For us, the normal point is that under 5, we have a plea bargain. The plea bargain, we have 2 different options. The plea bargain, the strict plea bargain, where you go with the general prosecutor and decide to make an agreement, and you say, okay, when they said from 2 years to 5, give me 3. Propose 3 instead of 5. And the guy said 3, and the trial is the trial will not happen. You know, the criminal trial will not happen because there's an agreement that I plead guilty, and the punishment, instead of going to 5, is 3. And we have another system, which means that you can reduce 1/3 of the punishment if you plead guilty. Yeah.
Saya bisik-bisik dengan beliau, plea bargain itu nggak pakai duit kan? Enggak. Plea bargain itu intinya kalau klien kalian itu sejak awal sudah kalian assess guilty, kita kan kemudian ya sudahlah, yang penting ikuti proses, and then judge will assess you, okay, as a guilty, you are a good person while in examination. So we asking the judge to reduce the punishment. Nah, di Spain itu terjadi secara bergaining. Tuntutannya berapa, dia udah ngaku kok segini aja. Nah, kira-kira begitu. Di kita kayak gitu dengan hal lain, kira-kira begitu. Yang kalian semua sudah tahu. I tell a joke with them. In Indonesia, yeah, we have a system, but some of bad cops. I can continue. Bad prosecutors use this system.
I understand what you're saying.
To fulfill their tummy. Okay, do you mind if there is any question,
yeah, sure. I would love.
Interrupt? Okay, we are all welcome, ya. Ketika ada pertanyaan, both in bahasa atau directly in English, you can tell tentang, ya. Oke. Pertama kita undang Mas Rifki dulu, baru nanti Anggun, dan terakhir mahasiswa. He's one of the public defender at my office. Last night maybe you.
We met each other yesterday, don't we?
Mungkin izin Pak pakai bahasa Indonesia ya. Ya, saya ingin melihat dari tadi yang disampaikan oleh Prof. Raul berkaitan dengan bagaimana sistem di criminal law procedure itu ada penyelesaian perkara itu melalui plea bargain. Nah, baru-baru ini atau yang sedang hangat dibicarakan kan berkaitan dengan pembaharuan kitab hukum acara pidana, yang salah satunya cara untuk menyelesaikan perkara di pengadilan itu dengan melakukan plea bargain dengan penuntut umum atau jaksa. Nah, memang kalau saat ini sedang dalam pembahasan itu mungkin saja plea bargain ini tidak untuk semua perkara atau dalam seluruh yang ada di Kitab Undang-Undang Hukum Pidana yang baru, tapi lebih kepada perjanjian atau tindak pidana berkaitan dengan lingkungan, terus juga berkaitan dengan korporasi untuk dia melakukan kewajibannya sehingga kemudian ada pengurangan dalam memberikan punishment di pengadilan. Atau selain itu juga ada deferred prosecution agreement atau perjanjian antara prosecutor dengan defendant atau pelaku. Nah, tantangan pelaksanaan di Spanyol itu seperti apa? Dan satu lagi yang berkaitan dengan kenapa di Spanyol justru ingin mengubah cara dalam melakukan penyidikan atau penyelidikan itu justru akan dipimpin oleh jaksa. Sedangkan di sini justru pada saat pembaharuan atau proses pembaharuan ini kita ingin memperkuat kewenangan hakim untuk mengontrol bagaimana proses penyidikan ataupun penyelidikan, terkhusus dalam hal upaya paksa yang dilakukan oleh penyidik. Begitu, Pak.
I gotta say, how beautiful Indonesian sounds to the ear, you know. I didn't understand a word, but it's like music for our ears, you know. Sounds really, really good.
Okay. We can continue, or you will respond first.
Oh, yeah, I will respond.
Okay.
Sure.
He said, in Indonesia now, we have the draft of the criminal procedure.
Okay.
One of that being discussed is about plea bargain that you have already told to us.
Okay.
Even though, according to him, this is not applied to all cases or crimes, but also in certain cases such as at environmental cases or corporate matters. Yeah.
It is not implemented on
this is still as a draft.
Okay.
But the draft it showed to us a bit, just because the legislative house asking the citizens how this law is good for you or not or something, and the draft is written. This plea bargain is only for the environmental case and also the corporate matters. And then he would like to hear the experience from Spain about the plea bargain. What is the implementation and the challenge over there? And the second, just because he hear from you that your country would like to change the view or the way investigation that led by the prosecutors, and it is done by Indonesia now. Just because Indonesia would like to ask more for the judge, because there are a lot of bad cops here, and then we need judge to monitoring, you know, like as a guardian or as the state to protect the human rights itself. How do you think about that? Okay.
I understand. I mean, the first thing, why plea bargains are desirable. Are desirable if plea bargains are desirable in a system that protects every single party right of defense and procedural rights. You know? And where the parties are put in front of the judge in an equal way, with equality, which means if, for example, in the example I brought, if you have only 3% of the cases in the whole country that goes to trial, I assume that the equality, the equal position between parties is not guaranteed enough. It could be a matter of doesn't have enough resources to prove, enough resources to have an efficient attorney or an efficient defense or an efficient procedural strategy. So, are they desirable? Of course they are. Of course they are when the parties are put in equal rights and obligations, when the right of defense is guaranteed, when the efficiency of the attorney defense is guaranteed. I mean, under the European law, if the judge think that the attorney's job is not being efficient for his client's interests, the judge will take action immediately. Immediately. So, when you have all the rights in equal condition established and guaranteed at the trial, why plea bargains are desirable? For two main reasons. The first reason is a matter of cost and efficiency. I don't know if this sentence fits in Indonesian culture, but you would say in the European and Anglo-Saxon culture that talking about business, time is gold, isn't it? You would say time is gold. Okay, when we're talking about trial, procedural law, time means justice. Fair justice. The sooner you give a solution to the parties, the better justice you are applying. For that reason, plea bargains brings to the table a cost efficiency matter, but also when it's developed with other kind of measurements, it could also work in the benefit of the victim's right. For example, in order to achieve an agreement, a guilty agreement, the general prosecutor demands that the civil responsibility related to the crime is already covered. So you not only will assume the responsibility, will assume the civil responsibility related to the crime commission, so you also will avoid the victim to be linked for 1.5 years, 2 years to a process that will demand, no matter what, his or her participation in that trial through declarations and other stuff. So it's a matter of fundamental rights protection, it's a matter of cost and efficiency of the administration of justice, but also it's a matter of victim rights. And in the last hand, it's also a way to show that, that the person committing the crime show and can understand the consequences of their actions
assuming plain responsibility without going to trial. So probably in the penitentiary law and in the Spanish Constitution and in the European Constitution for sure, the main point of view of the imprisoning penalty to imprison a person has one main reason: to resocialize that person and put him or her in society, the sooner the better. It has another, like the punishment. It has another one, like how do you say, special prevention. So the society can see that if you commit a crime, you will go to jail. But the main one put in the table in the Constitution is resocialization. So, and then the other question was, sorry? Regarding, did I express myself?
Ya, yang kedua tadi tentang ini kan,
berkaitan dengan kenapa di Spanyol, di Spanyol itu pakai
gonna change.
When you go to general theory of procedural law, the judge is the one that, I'm going to use Latin, that should be situated supra partes, on top of parties. It is not the judge works to be at the same level of the parties. It is not the judge, or should not be. In a fair system, the judge works to control cops or prosecutor apart from the specific trial that he's working on. The judge should be supra partes. Defendant, plaintiff, prosecutor, the judge. So when you put the judge at the same level of the parties, the risk that the judge's work, that the judge's figure is discolored, is diminished, is high. For that reason, the system you have here, like prosecutor, parties, judges, I would say is better. It's quite better. It's more guarantees. However, I have to say that Spanish judges with competence on investigation did an amazing job. An amazing job. They are really, really nice professionals with a high sense of responsibility and for the rule of law. But at the very end of the day, you as a criminal attorney will not confront the general prosecutor. You will confront the judge. The other party, your adversary, is the judge. Not the prosecutor, not the police, not the plaintiff, the judge. That cannot be happening. Okay? I think this.
Yeah, the second question from Anand.
Excuse me, I would like to ask about, as we know that in the court proceeding system that prosecutor represent the plaintiff or the victim, but he's here in plea bargaining system, I would like to ask that, is it the acceptance or the agreement between the prosecutor and then in the plea bargaining system, is it fully the consent of prosecutor as the represent of the plaintiff, or the plaintiff okay, sorry. Or is it the plaintiff also has a voice or a right to decide it whether the agreement is continuing or not? That's my question.
Okay, that's a really good question. In our system, we have a particularity is that every question will be about criminal procedure.
Yeah, I think.
It's the blood, you know, it's the blood. I mean, that's a really nice question. We have some specialty too. What is the main aim of criminal procedure? I mean, to make criminal law operate is the way you apply criminal law. However, in the Spanish system, we brought to the table other measurements, other point of view, and we recognize that one of the other aims of the criminal procedure is to protect victim rights. We should be balanced with, how can I say that, so, in a calm way. For that reason, for us, we allow the victim to be part of the criminal procedure with his or her own attorney as a plaintiff. So in the criminal procedure in Spain, you would have the general prosecutor that can apply for punishment or not, because the public prosecutor in the European system works for the rule of law, not to prosecute. You know, prosecutors in Europe works for the protection of the constitutional rights, for the protection of the judiciary independence and impartiality, for the protection of the procedural rights of the parties. So maybe the prosecutor might decide not to prosecute. Also, the victim has the right to be a procedural party and attend to the trial with his or her own representation. It's what we call acusación particular, particular prosecution. In other systems, the plaintiff is only represented by the prosecutor. Not for us. Not for us. Actually, for example, we recognize another point of view, another type of prosecution. What is called from the Roman law, civis ex populo, which is Latin. Civis ex populo, which means popular prosecution. Article 125 of the Spanish Constitution, 101 of the Criminal Procedure Code, and 270, in case you want to find it. The meaning of that is that any citizen, which means you have to be European, physic or not physic, any citizen, even a company, if it's a Spanish company, can pursue, an NGO can pursue a criminal case, can be a legitimate criminal party, can prosecute a case for the general interest. Not only environmental or urbanistic, no. In every single public criminal offense. Actually, It is pretty common that regarding corruption cases, environmental cases, and other type of cases, there's associations specialized on those cases that will be the popular or the people prosecution. You also find it in the gender violence courthouse. There's a lot of women associations that are present because, you know, in Spain we have the special court for women protection. Okay? That was a little, it was like, we don't have that, we have the court, that's it. That's it, you know. We have a court for women's protection's right. In cases a woman suffers violence at home, there's a special court for that. But only for investigation. Only for investigation. For trial, they go to general court. But for investigation, and for the civil measures related to that, for example, what happened with the kids, there's a special court for that. And there's also a special court for kids protection in civil jurisdiction. For that reason, we have a system of possible prosecution that is wider than the one developed in the rest of European countries, having the particular, or what you would say, private prosecution, which is the victim and the victim's attorney asking or demanding prosecution as a legitimate party. We also have the popular action, the popular prosecution, any citizen that will be a procedural party for the general interest, and the prosecutor and the public prosecutor. We have three. Did I answer? Yes, thank you.
Okay, the next one, before Chelsea. Okay. Yeah. The red.
She was supposed to.
Bismillah. First, excuse me. First, I would like to thank the moderator for giving me the mic, and especially, it is an absolute honor to be in the same room as the Professor Raul Gabriel Sanchez. Now, as you give me the permission, please let me state my question. My question to the Professor Raul is, do you think clinical education in Spain adequately prepares students for the realities of procedure law practices? Why and why not? As an add-on, to what extent do Spanish legal clinics incorporate real case works into their teachings of procedure law? Thank you.
That is the best question I've ever heard about education in Europe.
Who's your name, girl?
My name is Kiara.
Yeah. Where do you come from?
Aku mahasiswa regular di Fakultas Hukum UI. Half Chinese, half Indonesian, half American.
Okay.
Where does she come from?
From the law faculty. It's our first.
Kiara, pleased to meet you.
I'm also pleased to meet you.
Stating that there were only one clinic specialized in procedural law, the one I direct. Nowadays there's another one. And we have a situation cases, procedural law must be undertaken. Otherwise, the risk of not being able to solve the case prior to go to the courthouse and without doing things properly would have a consequence at the courthouse. And it will affect in a bad way the client's right. That's my opinion. Also, we developed two kinds of legal model. First of all, you know that the legal clinics model is concept was developed by an author called Frank. Okay? Through a system which is the American one, that it is based on a kind of law school that just prepare lawyers. That is not legal case. I prepare Jewish doctor. I do not prepare lawyers. I do not prepare judges. I do not prepare prosecutors. I do not prepare notaries. I prepare Jewish doctor. Which is a quite concept. For that reason, we bring the North American point of view on legal education. That is not importable 100% to the European model, neither to the Spanish one. We are based on the principle of resistance, also based on the principle of legality, Latin, externa, paraenia, and scripta. Lex, law, determine, previous, and written. Our system is based on that. So, if you only prepare your students to become lawyers, probably a big percentage of the professors of that university will be lawyers. That is not the way. That is not the way. So, for example, what is the discipline that has more present in the clinical education model in Spain? Philosophy of law. With all due respect and affect to my colleagues of philosophy of law. But they are not very close. Very close to know your work. What to say? In the name of the day, we are bringing to the table potential legal analysis through professors, supervision, considering that supervision is not made by a lawyer or by a person that has not been a lawyer ever in his life. So what we present is different. Our legal clinic is not based on the client. It is based on the student. We develop clinical legal clinic project in order for you to get a broad concept of justice, social justice, a first approach with supervision, to practice, and to give a service to the community. The nutrition is kind of rare that we attend individuals as Spanish legal clinics. It normally works out. Court proposal for notification, for example. The main guide that we have regarding administrative procedure law about medical treatment of some kind of complicated disease, I need the guide. How? At the clinic, we do students. We brought a guide for every single doctor that has the same. For example, you have, let's say, COVID, and the medical treatment is denied. Okay, there are the steps that you need to follow. That is how. Not to treat, not to attend individuals. To attend individuals, we do have the right to be represented by an attorney, court, guaranteed by the state. Also, at the Spanish system, we would have connection with what we would call clearing houses. Which means organizations that have the umbrella of several law firms that works pro bono for the cases sent to them. So, if we cannot solve at the legal clinics the situation, we will put it direct or the NGO contact with a big corporation that will work for free. But that has a little tiny thing that should be negotiated with the big corporation. In Spanish law, especially in civil procedure, we have the principle of the winning principle, which means the party that loses the trial pays for everything. Pays for costs and expenses. His attorney and the other one. If you need, for example, the report of an inspection, that costs money. So I ask the corporation, who will pay for that? Or the corporation. Or the corporation are so good that they always win. What happens if the corporation loses? The vulnerable people has to pay all lawyers. Oops. So, you are pretty sure that you will have 100% rate for winning cases? I can guarantee that. So, okay. I appreciate that.
I believe that answer was amazing. That answer was absolutely amazing. I noted every single little thing that the professor said. Thank you once again for the moderators and everybody involved. Wassalamualaikum warahmatullahi wabarakatuh.
Okay. Is there any question? One. How about two persons? Okay, this is the last. Okay, first I think Chelsea, and then.
I would like to thank Professor Raul for the amazing lectures. Let me introduce myself. I'm Chelsea, majoring in victimology, criminology, and forensic science. And since you mentioned about plea bargaining earlier, and also the civil procedural law on the kids' codes for children, I would like to ask your view and maybe give us a little bit of sneak peek on the Spanish procedural law in criminal procedure for juvenile system. because in our system we have the new codes that plea bargaining for juvenile system is going to be implemented here, and I would like to ask your views on that, on the criminal procedure matters. Thank you.
We have one, in my opinion, the best criminal justice system all over the world. The point of how the system established is as unfortunate as one it. We develop the nicest system ever can imagine. But if you don't try to make it happen, the system will not work. So the first point of the juvenile legal responsibility system is false. One, the system will not be there. The Spanish system is based out of a criminal law perspective. It is based out of a criminal procedure perspective. And it is also based out of a criminal procedure structure, concept, and system. Why is that? When I said that criminal offenses, the judge's direct investigation, not in juvenile, it's a public prosecution. But the public prosecutor works in juvenile from an administrative point of view. Which means when in criminal law, criminal procedure law, we call about summary in order for criminal documents, not case. In juvenile, we use administrative concept such as docket. The same concept used when you apply to the university for the mission expediente is the same word that we use in Kegiatan. So we try to think juvenile criminal responsibility outside of criminal law. First thing. Second thing, the juvenile system is not thought even to protect the victim or even to punish the killer. In Spanish, we have a difference between kids, is what we call kids, and all kids. We call niños, kids, and menores, all kids. When you talk to the American people, they can say, forget about the dog, they are all kids. If they are 16, they are kids. If they are 13, they are kids. They are all kids. So, the system is not based to punish the kid. It is based to give the kids resources and the possibility to develop a potential normal life inside the society. The system breaks media when some bad cases came to the table. Sure. This immediate kill, whatever, that's bad. That's really bad. But one case, two cases, cannot lead to thousand cases. 1 million cases. So if you're now trying to implement that, the first two cases you have that are kind of sensitive, probably the politician and the people will think, what's bad? We made a mistake if we listen to the table. But it is not a mistake. One of the cases can lead the community. Can legislate for the minimum cases. The last, the system is based on what we call an ATR for criminal responsibility. We have that for criminal procedure law, we have that in the criminal code, Article 80, and we have that for juvenile responsibility, which means after the investigation is over, the prosecutor will ask the kid that we can solve this if he accepts to say, I'm sorry that the parents pay for the civil responsibility and do some work for the community. These three steps in order to avoid to be punished. The punishment under juvenile law, criminal law, consists of going to a facility that is kind of close, prison, it's kind of close, but instead of security guards, you have ordered people specialized on kids education. And you also have security guards. You know, but the kids interact the majority of the time with the parents.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aziza, sir, and I'm part of student staff in LKBH FIUE. And also I'm sitting here with my friends, and they are student staff in LKBH FIUE too. And we were wondering, and we would like to ask you about the legal clinic model in Spain procedural law. How does the legal clinic model in Spain procedural law like?
Sarah, agak pelan-pelan dikit.
Okay. Sorry. Do law students like us or student staff like us allowed to directly participate in certain stage of procedural work such as drafting document, assisting mediation or even consultation, or do they even have a change or right to talk or to stand as a defender in the court? We were wondering how far a student staff can do in Spain procedural law. That's all. Thank you.
She tried to consider, or I mean the try to wait a second, to seek any information from Spain, especially for the student staff that involving at the clinics. Whether the student staff can assist for the community or the clients or the person that came to there, not only into the court, but just non-litigation ways, such as one to be a mediators or give legal advice. So then the community or the clients will be confirm their rights, and then they can do something after they finish at the office. Yeah.
First of all, legal advice might be given by legal practitioners. It is prohibited under the European system that a person that is not a Jewish doctor gives legal advice. So what we do is that I would say my kids, because I'm like a father for them. My kids give legal advice in the presence and with the supervision of an attorney or myself or another colleague. No, never by myself. If one of them gives legal advice without supervision, he will run a lot around the university. Because I'm going to be after him with a gun, you know. So no, they cannot give legal advice. Giving other type of services that are not law related is forbidden. That is a decision I made. And I explain why I made that decision. We are Jewish doctors. We should be specialized on the cold application of evidence law. That's it. That is our job. To take the evidence, link it to the facts, and try to get the better solution for our clients. We don't go further. If we go further, the possibility that we lose our mind in sectors that we are not specialists, for example, I'll give you an example. We have a tough situation there with the person, really tough situation. So people at the clinics try to help that person find a job, talking to the newspapers, looking after kids, and I said no. As soon as you get person involved in the case, they're lost, and the client is lost. So the whole rule of law and practice of evidence, that's how we do it. But the mediation thing is something I've been considering for a couple of years. It's published. Can my student mediate? No, it's forbidden, because you need to have some special title to be a mediator. And you cannot be a mediator if you haven't got a university degree. For us, mediator can be lawyer, psychologist, social worker, social educator. Not only so they cannot mediate. However, that would be really nice to have a mediation system inside of the clinic. That is the future of European legal clinics. Why? Because if in every single civil case, as a requirement to proceed with legal action, you would need to show proof that you try mediation or other forms of friendly solution of the controversy, there will be people that cannot afford that. And there is not a body of public mediator yet. And there will not be a body of public mediator. So that is a job that can be performed at the legal clinics for sure. Really necessary.
Thank you very much, sir.
Okay, thank you so much. And I think we have at the final time, because it is we have run out of time, yeah. And then maybe you would like to share the last words. I mean, what is your thought for our students? What should they do when they were studying law?
Interested on the legal topic, that is where nowadays unfortunately, and the main advice I might give you is that as a teacher gives doctors, the main thing you should do is read. To read every single day. If you want to become a professor, if you want to become a judge, if you want to read every single day. My normal routine when I get up in the morning is I go to the official newspapers of the country. I go to the Google. I go to the official newspapers of the European Union. I go to the newspaper. The normal newspaper. After that, I think the project, the second occasion after that, I read one decision from the Supreme Court and an article. After that, my day starts. That's enough. That's enough. So the best weapon you have against bad society situations is a book. That's your weapon. That will take you out of the concentrated chair. Take you out of the world environment, of the world hall. Read every single day. You need to be on top of the Supreme Court decision. It cannot be one Supreme Court decision related to your specialization that you don't know. That cannot happen. What they do, every Supreme Court judicial decision, have it by writing in a little paper. Traditional work. I want to be specialized in criminal procedure law. Okay. Certain devices related to resolution. Here they are. What do they say? Here they are. What is Professor thinks? Here they are. You need to be on top of your discipline. You need to be ahead of your discipline. And that means read. Okay? And if you're lawyers, don't forget to back.
Thank you very much, Mr. Prof. Raul Gabriel Sanchez Gomez. As our religion teach us at the first time of Quran in our word, in Surat Al-Alaq, Iqra. Iqra means read. It's suitable. Okay. Thank you so much for coming and your time, Ms. Professor. We would like to hear maybe or read your books or your journal. You may found it in okay. in Orchid. You may find it, and then let us end this forum with recite Hamdalah. Alhamdulillahi Rabbil Alameen. Before end this forum, is there any another? Okay, so we have a souvenir for you, and we would like you to stand at the front, and we would like Miss Dr. Aroma to present the gifts and the souvenir for Prof. Raul Gabriel Sanchez Gomez. First is souvenir from Law Faculty of Universitas Islam Indonesia. Please welcome, and okay, take a picture. Oh yeah. Okay. Next is about another souvenirs. Okay.
Satu, dua, tiga.